Good afternoon, all of you. Okay, I hope you all are doing well. So I'll be taking discussion for topics which are polity, and of course I'll also be letting you know about the number of questions. Just a second. Okay, so primarily we will be having different sessions. Okay, and they'll be divided as per the subject. So which all subjects I'll be discussing? Polity and governance, there are 12 questions. Okay, and international relations, there are 5 questions, which are, and then we have 4 questions which are related to polity and governance with respect to current affairs. So there are 12 static questions and 4 questions which are related to polity and governance, but they are of current significance. Then we will have international relations, 1 current affairs question, and there are 2 questions which are of social issues, so we'll be discussing. So altogether I'll be taking 24 questions. Okay. Being honest, it is not a watertight blanket compartmentalization. So in UPSC, I am sure you know that it's just my duty to reiterate the same. So we cannot have a black and white discussion where a topic belongs to a particular thing. There are interdisciplinary approach, and the syllabus has been so drafted to keep in mind that things which are interrelated have been placed under one topic. Okay, one subject. For example, you have polity, that is Indian Constitution, that is in paper 2. So while you must know the implementation of it and the main principal mandate of a civil servant, that is governance. So along with Constitution that placed in paper 2, that is governance, GS paper 2 I'm talking about. And then what you will be promoting, social justice. So it is also there, and international relations is there. But it is equally naive to say that anything that is in one paper has no significance with other. I can give you so many examples just to put few. For example, you have Finance Commission. So in 2021 mains that was conducted in 22, they asked a question on Finance Commission in paper 3, GS paper 3 in economics. So Finance Commission can be asked in paper 3 also, and can be asked in paper 2 also, though it's same goes for ethics, integrity and aptitude. So there are many aspects which have an interdisciplinary approach, and the syllabus has been so drafted to keep in mind that interdisciplinary aspect, but still there are some gray areas where they can ask questions. Just to say one thing, for example, social justice has been kept in paper 2 while society has been kept in paper 1, because society is the product of historical evolution, how caste and other systems have evolved over the period of time, which has come from ancient, and getting my point now. So that is also a reason they have kept society in paper 1. And while exercising governance, while you will be doing governance as a civil servant, what will you promote? You will promote the social justice. So social justice has been kept in paper 2. Before we begin, very soon we'll be having questions at the portal, so that they will be at display, and then we'll discuss that. Okay. So just one more thing with respect to this. For example, if you see GS paper 2, okay, so there are few questions I was going through that have what you call current significance. So this has been a habit, especially the kind of questions that are asked from 2012, which have been 2021, which have been reiterating time and again. The psyche of UPSC has completely changed, and this is the reason why the cutoff went to up to 75 this time, because I don't find those questions which were asked, at least when I see the papers of last 3 years, so those questions that were asked before 2021, they cannot be seen as benchmark. Those questions were asked, although without an iota of doubt, practicing previous year's question paper remains the most important thing. Any test series, of course, will come secondary to previous year's question paper. That remains the ultimate benchmark. But the kind of questions that were asked before 2021 were very simple. You see 2018 question or 17 question, who takes a decision under the 10th schedule. Then they are asking a question on social, economic, political justice on Article 38. They are asking a question, which among the following is not a fundamental duty. They are asking a question, what is right to vote. They are asking a question on the principle of equality in Article 14. So questions were straightforward. Now what UPSC has done, which I primarily want to emphasize, they have increased the element of governance. They have increased the element of governance, and under the garb of asking questions from polity, actually they are asking questions from governance. 3-4 questions would be there which will be plain and simple, various aspects of fundamental rights and other things related to that. But questions like Indian Prisons Act, which they ask, questions like Official Secrets Act, questions like H.N. Sanyal Committee, questions like McBride Commission, although it was asked quite in somewhere down the line, 4-5 years more. But if you see 21 to 24, these what is the size of the flag? That was asked from Flag Code of India 2002 that you can find on the website of Ministry of Home Affairs. Then they asked the question, right of person with disabilities in mains. So mainly, even if they are asking a question from Indian Constitution, they have emphasized few basic things. One, that if they are asking a question from Indian Constitution, first statement would be a static one, but the second statement would be a dynamic one. So Office of Governor has been in news and I'm expecting a question very soon. So Article 200, approval of bills by the governor. So they will ask a question that is a static first statement and second statement would be a dynamic. So, and second thing what UPSC has done, according to the Constitution of India, Attorney General resigns when the government changes. According to the Constitution of India, the term judicial review is mentioned in the Constitution. According to the Constitution of India, the doctrine of basic structure has been defined. So what they want, okay, what they want people to, for that matter, to go through the primary text of the Constitution. They want people to go through the prime text of the Constitution. That is something which is very, very important. Just a second. Okay, so I'll be starting those questions. Just a second. Okay, so dear students, if you see according to the Constitution of India, so there are articles from Article 1 to 395. Okay, so I am not asking you, it is neither practical nor I am asking you to go through all the articles. It is not feasible. I am teaching for 8-9 years, so I remember almost all of them, but it is not possible, neither required from your end. But without a shadow of doubt, those articles that have been in news in last 1 year, you must go through these articles directly from the text of the Constitution rather than doing it from any secondary source. So those articles like what is the article related to approval of bills by the governor, what is the article related to address of assembly session by the governor, Article 176, Article 200, what is the relationship between Council of Ministers and the governor, Article 163, what is the relation, now Article 79 to 82. Article 79 to 82, there is a provision related to new parliament has been inaugurated. What is the provision related to delimitation? Even from the political context, the term delimitation has been raised by, we are nothing to do with politics, just giving, it is in news. It is in news. So of course that has to be covered, okay, from Article 79 to 82. Then you have provisions related to census has been postponed. So it will be naive not to go through Census Act 1948, you know. Then you have the constitutional amendments that have happened. So all those things that are in news in last 1 year, you will also go through the articles of the Constitution directly. So that is why UPSC is asking a question from Article 76. According to the Constitution of India, Attorney General resigns when the government changes. Now there is no such provision in the Constitution, but repeatedly UPSC is asking a question according to Constitution of India. So all those things that are in news, you will prepare a long list of that and you will read the articles in the Constitution related to those. And whenever you are reading a topic that is static, okay, that has to be incorporated, that has to be what you call linked with the current affairs. One more thing, then we'll be starting with the discussion. One more thing, ki you cannot take those questions which were asked 5-6 years as down the line as benchmark. You see the 14 questions were have been asked in last year, 13-14 questions average in last 3-4 years they are maintaining. I was very meticulously going through the questions in prelims as well as in mains. In mains stage of the examination, they have reduced the average difficulty level of the questions. In prelims stage of the examination, they have increased the difficulty level of the questions, and that is why the cutoff is going low. Mains was quite easy. Direct questions, what do you mean by constitutional morality? Discuss the cases related to constitutional morality. Do you think that right to free and compulsory education act is able to incentivize school education in India? So these questions which they have been asking, which have been quite easy. Okay, so what should be your strategy? Those first, you need to have patience. Absolute patience in the examination hall, because 75 cutoff is not a big number. Even the kind of preparation that you have, if you are calm in the examination hall, very comfortably you will sail through the requisite marks. So you need to have absolute patience in the examination hall, and practicing is something that is required. So please don't panic over this. This exam was more about testing your mental endurance rather than your command over facts. Okay, so I have the list of questions that I will be discussing. since it is going to be a very industrious long session, and I do have been allotted a stipulated time, so I will not be venturing into the domains that are not directly related, but still I'll try to cover topics that are ancillary or somehow related to the question. The purpose of this discussion is not to load you with facts. Okay, the explanation, thank you. The explanation that will be provided to you is enough. Purpose of this session is to enhance your knowledge skills, in the sense, not information, knowledge skills, to make you more capable to deal with the upcoming exam. How you should thinking, because the art here is to develop that intuitive thinking within you. Okay, so the first question, dear students, that we have is question number 11 for polity. So if you see this question number 11, okay, this was an easy question from what you call directive principles of state policy. So my prime focus remains that I will be discussing this question, but I don't want to stick to this question only. What are the expected questions that can be asked from this, that we will also do? Okay. DPSP is one such topic. Today morning I was saying DPSP is one such topic which has been consistently asked by UPSC. First reason. Second reason, why it has been consistently asked by UPSC? Reason being very simple. As a civil servant, what will you be doing? You will be exercising governance. You will be exercising governance. So this is part of your job profile. This is part of your work profile. What is government? Government is the set of people who have the authority to govern. Government is the set of people who have the authority to govern. And what is governance? Social, economic, political and other decisions taken by government. So governance is a verb. Government is a noun. Getting my point? So you will be exercising governance as a civil servant. So repeatedly UPSC is asking question from directive principles. First thing. This is the thing, that is a fact. Second important thing. Usually students do not make a mistake in DPSP. I don't find at least 40,000 or 30,000, whatever students have, I don't find students usually making a mistake in DPSP. So usually they are not able to trap you in DPSP unless they ask a question which is ancillary. What is an ancillary question? For example, you have Article 42 of the Constitution, that the state shall provide maternity relief. Okay, maternity relief. So Article 42 is provided in the Constitution that state shall take care of just and humane conditions of work and maternity relief. This is a plain fact that is given in Article 42. But UPSC will be asking a question from Maternity Benefit Act 1961 as amended time to time, and the maternity relief has been increased from 12 to 24 weeks. So ancillary question that is related to the article, there they can trap you. I'll give you one more example. Article 21A of the Constitution says that the state shall provide free and compulsory education to all children in the age group 6 to 14 years. This UPSC will never ask. This UPSC will never ask, because even a person who is not preparing for civil servant, he's having a grocery store, he also somehow has heard that the state shall provide free and compulsory education to all children in the age group 6 to 14 years. Next line is there, in the manner state may provide by law. In the manner state may provide by law. So UPSC asked the question, Right to Free and Compulsory Education Act 2009. That was a mains question last year. So what I am saying ki those DPSPs, now UPSC will be moving further. Those DPSPs that are plainly provided. What are the laws that have been enacted to implement those DPSPs, especially in main stage? Here they can ask questions. Now one question. Now this I am following the pattern of UPSC. If UPSC asks a question according to the Constitution of India, the directive principles have been divided into which of the following? According to the Constitution of India, directive principles have not been divided. According to M. Lakshmikant, directive principles have been divided. Similarly, they asked a question, for example, that the Constitution of India explicitly mentions which kind of vetoes. Absolute veto, qualified veto, suspensive veto, pocket veto. According to the Constitution, Article 111, ito, veto, keto, no such term is mentioned in the Constitution. So you must be conscious ki what is given in the secondary text and what is given in the Constitution, and then you make a mistake. Third, According to the Constitution of India, which kind of majorities are provided in the Constitution? Simple majority, special majority, absolute majority, effective majority, special majority with the consent of states. No such term, special majority, effective majority, absolute majority term has been used, simple majority term has been used in the Constitution. But these are terms which are used for academic significance. So you should be absolutely clear what is mentioned in the Constitution and what is mentioned in any textbook that is related to the Constitution. And I'm again saying this year again they will ask a question according to Constitution of India. Message is loud and clear. Don't remember the Constitution by heart, but those articles which are in news all the time, you must go through the primary source, that is the Constitution. Now we will take this question. It says the directive principles of state policy mandates the state to organize agriculture and animal husbandry on modern and scientific lines, and is based on which of the following philosophical principles. So first of all, that one more thing, can we straight away divide a particular directive principle as a Gandhian? No, because there are some directive principles. For example, Article 43. Article 43 says about living wage, which is a socialist principle, but cottage industry in the same article is a Gandhian principle. Article 48, that is what you call agriculture on scientific lines, and ban on the consumption of intoxicating drinks, slaughter of cows, calves and milch and draught cattle, that is Article 48, which is partially a liberal intellectual principle and partially a Gandhian principle. Article 47, animal husbandry and agriculture on scientific lines, first part which is a liberal intellectual principle, and second, the prime purpose of the state should be to take care of public health. That is Article 47. And the second part is, in particular, the state shall bring about prohibition in the consumption of intoxicating drinks and drugs which are injurious to health. So Article 47, part 1 of Article 47 is that the state shall take care of public health as one of its prime duties, which is a socialist principle. Part 2 of Article 47 is, in particular, bring about prohibition of consumption of intoxicating drinks and drugs, which is a Gandhian principle. Again, in Article 48, animal husbandry and agriculture on scientific lines, this is a liberal intellectual principle. But second part, ban on the slaughter of cows, calves and milch and draught cattle, which is a Gandhian principle. So you cannot say that one particular article falls under the socialist principle or Gandhian principle, because there are three articles, Article 43, Article 47 and Article 48, that fall under two brackets. They are Gandhian socialist, they are liberal intellectual as well as Gandhian. So first clarity that you should have. Second, this was an easy question. I'll take this as a very easy question. Even if you are reading newspaper consistently, you will be able to solve this question comfortably. It says, the DPSP mandates the state to organize agriculture and animal husbandry on scientific lines. This is pure Article 48 of the Constitution. It is the duty of state to provide for agriculture and animal husbandry on scientific lines, which is a liberal intellectual principle. Second part is the Gandhian principle, which says ban on the slaughter of cows, calves and milch and draught cattle. So it is a liberal intellectual principle, and they have written modern and scientific lines. Now anarchism, nihilism, conservatism and progressivism. Anarchism. Anarchism means that although we say anarchy as anarchy is seen in a bad light, but the concept of anarchy has come from an ideology which believes, one of the Western scholars have said that anarchy is the best form of government. Anarchy is the best form of government. We, in our common parlance, we understand that anarchy means complete chaos. But what anarchy means? Loss of government. There should be no government. So when the civilization has reached a stage where people are so mature that they don't need civilization has reached a stage where people are so mature that they don't need a government, and that is, then it leads to anarchy. So anarchy can be at both the level. It can be the best form of government, or it can be the worst form of government, that is absence of government. Here anarchism means there is no government. There is no government and there is no public order in agency to enforce public order. So in that sense, how does anarchism related to agriculture and animal husbandry? Agriculture and animal husbandry, if any, is related to liberalism, if any is related to intellectualism, if any is related to progressism, if any is related to a secular idea. What is a secular idea? Other than religion also, secularism means rational thinking. Secularism means rational and scientific thinking. So at best we can call it a liberal intellectual thing. At best we can call it a progressive thinking. Somehow we can call it a sort of secular thinking devoid of religion, but more about progressive modern outlook. But we cannot call it anarchism. So this cannot be an anarchism. Nihilism is an idea that basically that doesn't believe in traditional values, that doesn't believe in customary values. Those people who want everything should be dismantled. Complete dismantled, traditional values, customary values, traditional institutions are not respected, everything should be dismantled, and that is nihilism. Do you think that organizing agriculture on scientific lines would lead to dismantling of traditional values? So it is nothing related to directive principle. In college we used to be idealist. So some students used to discuss nihilist theory. They said there is meaningless in life. कुछ बच्चे होते थे बहुत ज्यादा नेगेटिव साइकी रखते थे. All the time they used to discuss negative things. They used to discuss about what you call the idea of religion. And they said, one of my friends from St. Stephen's, he used to say that everything is meaningless. There is nihilism in everything. There is no meaningless, there is no meaning in life. Life is just what you call a very mirage existence. So it is dismantling all the traditional, what you call customary beliefs and all. So it cannot be seen as agriculture on scientific lines. Then you have conservatism. Now you have two words. Conservative, sometimes you will say, okay, their family is very conservative. And sometimes you will say that is liberal. Sometimes you will see that they are liberal. Believe me, liberal term itself is a 2-hour discussion, but I will not go that deep. So what is conservative? In a simple sense, conservative is one who resists change. In a plain language, conservative is one who resists change. So when we say that she or he is married in a conservative family, so we say that this family is not open to ideas. Now the counter argument is liberalism. For example, we say right-wing parties. Right-wing parties are those parties that are status quoist, those parties that are conservative, those parties that are they take more pride into upholding the customs and the traditions. We have nothing to do with politics, just discussing. Liberalism kya hai? Liberty is responsible use of freedom under rule of law. So although I don't want to go much deep, but what is liberty? One, there should be two things. There should be least intrusion into your expression. The way you want to express yourself, there should be least intrusion by the state. John Stuart Mill, Rousseau, Locke, especially John Stuart Mill, in his essay on liberty, he has exhaustively talked. One. And then you must be allowed to express yourself fully. And how the state promotes those institutions that allow you to develop fully, that we will discuss. There is one more question on liberalism, so I'm not expanding the conversation now. We will discuss exhaustively on that. So, दो aspect है, एक है conservatism. There is one aspect which is conservative, which is rather emphasizing on those institutions that are traditional, that are customary, and they resist change. And the argument, liberalism, which are more open to ideas, but the idea of liberalism has come from state perspective, that state should not impose restrictions on human individuals' expression. That is negative liberty. And then positive liberty, entire life of Amartya Sen and scholars like Abhijit Sen, especially welfare economist scholars like Amartya Sen and Nobel Prize, they have emphasized on welfarism and positive aspect of liberty. Maximum expansion of human choices. So if we see what is the question here, the Vision ABHYAAS Abhyas series is asking, the DPSP mandates the state to organize agriculture and animal husbandry on scientific lines. Agriculture and animal husbandry on scientific lines. You are a better judge to decide that we cannot say anarchism has nothing to do with animal husbandry on scientific lines. Nihilism means dismantling everything meaningless in life. So how can meaninglessness should be agriculture on scientific lines? So we will, conservatism does not mean science. Conservating means being status quoist, going into those customs and values that have been upheld for a long period of time. So the only answer that we will have is progressism, and progressism is promoting those ideas which are forward-looking, promoting those ideas which are progressive, promoting those ideas that are far-reaching, that will bring changes in the society, that will have an impact on rational secular thinking. Okay, so the correct answer would be D for Delhi. Okay, now the next question we have is 12. This is an easy question. First of all, what all articles you should know? I think that you should know article if you can just quickly note down, okay, you should know Article 130, Article 124, you must read without an iota of doubt. Article 129, Article 130 is the principal seat of Supreme Court. Getting Article 130, Article 124 is the most important article, appointment of judges of Supreme Court. Article 129 is Supreme Court as a court of record and having the power of contempt. That is Article 129. Article 130 is the principal seat of Supreme Court. It says the principal seat of Supreme Court shall be New Delhi or other places with the Chief Justice of India in consultation with the President will decide. So Article 124 appointment of judges, Article 130 seat of Supreme Court, Article 129 Supreme Court as a court of record. So 124 पढ़ के जाइएगा, 129 you will see, 130 you will see. Article 131, that is federal dispute between center and center and some states on one hand versus other states. That you must read. Article 132, appellate jurisdiction of Supreme Court on constitutional matters. Article 133, appellate jurisdiction of Supreme Court on civil matters. Article 134, appellate jurisdiction of Supreme Court on criminal matters, again very important. Article 136, Brahmast of Supreme Court, that is special leave petition. Article 141, judgment of Supreme Court shall be binding on all courts in India. Article 142, again it is very, very important. In order to do complete justice, Supreme Court can do anything. This judgment was invoked in the release of the, what you call, the Honorable Prime Minister Rajiv Gandhi ji's. In that case, the killers were released. Supreme Court invoked Article 142. Article 143 is advisory jurisdiction of Supreme Court, and Article 145 is the constitution of a constitution bench. Okay, that is Article 145. Now, this question is related to Article 137, and this question was asked by UPSC in 2021. Again, this question has been, but this question was asked related to High Court. Now, this is a tricky question. Why it is a tricky question? Here it is easy, but they made it a tricky question. 90% of the student got this question wrong 2 years back. क्या question था UPSC ने पूछा? Now, Article 129 of the Constitution says that the Supreme Court shall act as a court of record and shall have the power to punish for its contempt. Article 129 of the Constitution says that Supreme Court shall act as a court of record and shall have the power to punish for its contempt. समझ लिया? Article 215 of the Constitution says High Court shall act as a court of record and High Court shall have the power to punish for its contempt. So Article 129 makes Supreme Court a court of record and the power to punish for its contempt, and Article 215 makes High Court as a court of record and power to punish for its contempt. Any court that is a court of record, there is a jurisprudence, philosophy of law. Any court that is a court of record can review its own judgment. 2 questions have been asked in last 5 years. On this topic, UPSC has asked 2 conceptual questions in last 5 years. One question, I don't remember, 18, 19 they asked, and again they have asked in recent past. 2 questions they have asked. So, any court that is a court of record, कोई भी ऐसी court जो court of record है, it has the power to punish for its contempt. कोई भी court, any court that is a court of record can punish for its contempt, and any court that is a court of record can review its own judgment. Reviewing its own judgment का मतलब होता a judgment that you have delivered, you can revisit that judgment. So in general, philosophy of law is that any court that is a court of record can review a judgment that has been delivered. So UPSC 2 years back asked the question, High Court as a court of record has the power to review its own judgment. UPSC said that High Court also has a power to review its own judgment, as it is mentioned in Lakshmikant, as it is mentioned everywhere. 99% of the students and most of the answer keys that were released that year gave that yes, High Court also is a court of record under Article 215 of the Constitution, so High Court can also review its own judgment. But UPSC released its answer key and took that statement as a wrong statement. Why this issue happened? Because Supreme Court acts as a court of record and punish for its contempt. High Court acts as a court of record and punish for its contempt. But nowhere it is written that High Court can review its own judgment. Only it is for Supreme Court it is written in Article 137 of the Constitution that Supreme Court can review its own judgment. So what UPSC wanted to convey, that why are you inferring something from yourself from Article 215? We will not buy that argument. In the Constitution it is written for Supreme Court in Article 137 that Supreme Court can review its own judgment. Nowhere in the Constitution it is written that High Court can review its own judgment. It is a common sense philosophy of law that any court that acts as a court of record can review its own can review its own judgment. So UPSC went by the fact that no, whatever is explicitly mentioned in the constitution, we will buy that. Whatever implicitly you're drawing from any textbook, that we will not buy. So the answer key that was released, that Supreme Court can review its own judgment, but High Court cannot review its own judgment. So this statement was taken by UPSC as wrong, and so many students made this mistake. So current position is, so that you don't repeat that mistake again. 1, Supreme Court has the power to review its own judgment. High Court doesn't have the power to review its own judgment, even if it is mentioned in the book, because what UPSC says is final, because there is, reason being, there is no explicit provision in the constitution which empowers the High Court to review its own judgment, but there is explicit Article 137 that empowers the Supreme Court to review its own judgment. Third point, Supreme Court as a court of record and punish for its contempt. This is equally applicable for Supreme Court as well as High Court. Article 129 for Supreme Court and Article 215 for High Court. So now you understood. Now I'll take you to one more question which UPSC asked 6 years back, 5 or 6 years exactly, I don't remember the year. They asked this question that the term judicial review means the Supreme Court reviewing its own judgment. So what UPSC did cleverly, they mixed judicial review with reviewing its own judgment. Judicial review is an entirely different philosophy. The term judicial review is neither mentioned in Indian Constitution nor mentioned in American Constitution. The concept of judicial review has 3 major components as defined by Supreme Court. What is judicial review? Reviewing a constitutional amendment, reviewing an ordinary law, and reviewing an executive action of the state. This is what Supreme Court has said. These 3 things are judicial review. You are not going to confuse between judicial review and reviewing its own judgment. Judicial review means court is reviewing a constitutional amendment, an ordinary law, and executive action. Reviewing its own judgment ka matlab hai, you review a judgment that has already been delivered by you. So what UPSC gave a statement that judicial review means the Supreme Court reviewing its own judgment. That was a wrong statement. So never get confused between judicial review and reviewing its own judgment. Reviewing its own judgment is explicitly provided in Article 137. Judicial review is explicitly not provided. It is an inference coming from Article 32, Article 13, Article 131, 132, 133, 134, 136, 145, 143, 226, 227. These are the articles that highlight towards judicial review. Although the term judicial review is not mentioned in the Constitution, neither in Indian Constitution nor in American Constitution. The concept of judicial review to the world has been given by the landmark judgment that you all know, that is Marbury versus Madison, delivered by American Supreme Court in 1803. But the term judicial review is neither mentioned in Indian Constitution nor mentioned in American Constitution. Now we'll read this. The Supreme Court cannot deviate from its previous judgment. True or false? False, because Article 137 of the Constitution says that the Supreme Court can review a judgment which is had previously delivered. So this statement is a wrong statement. Supreme Court is a court of record, Article 129, and its judicial proceedings are recognized as legal precedents. Yes, Article 129, any court that is a court of record, its proceedings are a precedents, and Article 141 of the Constitution. Every judgment of Supreme Court shall be binding on all courts in India. Article 141 of the Constitution, every judgment of Supreme Court shall be binding on all courts in India. So without an iota of doubt, this statement is a correct statement and this statement is a wrong statement. So we will settle for D. Statement 1 is incorrect while statement 2 is correct. I am not concerned with this question beyond this fact. I am more concerned about you knowing Article 131, 132, 133, 134, 136, 143, 145, 129, इतना तो आपको मालूम होना ही चाहिए. You must know, because there will be a question from judiciary. They cannot ask anything beyond this. Okay. So whoever sets the question paper doesn't set in an abstract manner. They have the syllabus before them. Okay. Although in prelims they have not meticulously. Every topic they will be taking 1 or 2 questions. So without an iota of doubt, they will be asking questions from judiciary. And if they ask questions from judiciary, they will only ask from these articles which I have mentioned. If you have diligently noted down, it will be beneficial, I hope. Okay. Now we have our question number, we are giving too much time. Now we must be question number 13. Okay. Next is question number 13. Yes. Okay. Now this question is a hot burning question. Kyun? Why? There have been series of issues related to Office of Governor. So I am expecting, see, we cannot be too sure. We can only say what is important, and without an iota of doubt, this is important. Few as 5-6 things related to governor. I'm expecting one question in prelims. Pehla, calling of an assembly session. Calling of an assembly session, I'll give you reason. Punjab government moved Supreme Court last year because Council of Ministers made a recommendation to Chief Minister primarily made a recommendation to call an assembly session, which was not immediately accepted. So Punjab, I have that judgment also in my mobile, original copy. So calling of an assembly session, which was not accepted, so Punjab government moved Supreme Court, first thing. Second thing, many ministers, we are not going into politics, we have nothing to do with, but many ministers are in jail, especially in related to one of the honorable minister in Tamil Nadu, but not dismissed. So Article 164 of the Constitution, can the governor dismiss a minister without an advice coming from the chief minister? This was the same issue that happened in Tamil Nadu. This was the same issue that happened in Kerala. This is the same issue that happened in Delhi, Article 239AA clause 4, getting my point. Although in Delhi the ministers are not appointed by LG but by the president. Okay. So this is a second issue. First is calling of an assembly session. Second, dismissal of a minister. All these issues require 15 minutes, but I don't have time. Okay. Third is the most important, that is approval of bills. That is Article 200 of the Constitution. That is Article 200 of the Constitution, in which last year in September or October, Supreme Court delivered a landmark verdict on approval of bills, which I also discussed in the current affairs. You can go and visit the Vision ABHYAAS current affairs also. So that is Article 200. Fourth important thing that is related to is address of the assembly session. Address of the assembly session. In what happened in 2 states, I will not name. The governor was addressing the session. So there is a practice. You have Article 87 of the Constitution and Article 176. Article 87 of the Constitution says that the president will address on 2 occasions, first session of every year, and when a new Lok Sabha comes into life, first session of that Lok Sabha. So every time Article 87, and the replica of Article 87 is 176, that the governor will address the sessions. One is the first session of every year, and second, when the new state legislative assembly comes to life, governor. Now there is a customary practice which I have been seeing since my school days, that the governor or the president addresses, usually the president, because it used to be a live telecast. Governor, of late, we are lucky that many assembly sessions are live on YouTube and all, so we can see that. Initially there was no technology. So usually what happens, in this case what happened, the speech is approved by the Council of Ministers. Council of Ministers जो speech approve करते हैं वही governor पढ़ते हैं. So governor reads out a speech which is forwarded by the Council of Ministers. What happened in one state, without naming that state, the speech which was approved by the Council of Ministers was not read by the governor. So some portions of the speech were skipped. So this is a convention which we have inspired from United Kingdom. This is a convention which we have inspired from United Kingdom. There also the Queen addresses. Now we have the King. They have the King. Okay. So in our country, India, in our sense, this is what we have. From their convention, we have incorporated a provision in the Constitution. So now this happened. So this can be a question. And fifth is the appointment of Vice Chancellor. The appointment of Vice Chancellor. So first, that is the relation, the calling of an assembly session. Then you have approval of bills. Then you have dismissal of minister. Then you have governor's address. Then you have removal of Vice Chancellors. In general, I am expecting a question from Article 163 of the Constitution. That is that article which is related to the relationship between Council of Ministers and the governor. And there is a parallel article, Article 74, relationship between President and Council of Ministers. So you have Article 74, relationship between President and Council of Ministers, and Article 163, relationship between Governor and Council of Ministers. I am expecting a question in prelims this time. Okay, let's see this. With reference to the Governor's address, Article 176, the state legislature consider the following statement. The Constitution gives Governor power to address first sitting of legislature of each year. Yes, and the same power is also given to the President, Article 87 of the Constitution, but also you must read Article 86 of the Constitution. 87 and 86 are same but different. 86, President can send messages to the House. Okay, so 86 is not invoked quite easily. So UPSC may trap you by not asking a question from 87, but 86 is something very similar but not that same. So you must go through 86 also. Just please read once. The office of Governor prepares Governor's speech. Who prepares Governor's speech? The Council of Ministers. So this statement is a blatant wrong statement. The Constitution of India mandates that governor cannot deviate from text of the speech. These things are not written in the Constitution. These things are not, Constitution doesn't mention these things. Constitution, Article 163 of the Constitution, there shall be a council of ministers headed by the chief minister to aid and advise the governor, except in those matters on which the governor is expected to act in discretion. That is clause 1. Clause 2, if there is a dispute related to if there is a question whether a matter falls within the discretion of governor or not, the discretion of governor shall be final. So Article 163 primarily conveys two messages. One, the governor shall act on the aid and advice of council of ministers except on those matters where the governor is expected to act in discretion. Second, if there is a question whether a matter falls within the discretion of governor or not, then the decision will be taken by governor and his decision will be final. Third thing which they can ask in mains, difference between president and his council of ministers versus governor and his council of ministers. There is no discretion term mentioned related to president, but there is discretion term mentioned related to governor, because of maintaining the unity and integrity of the country. So Article 74 of the Constitution, the President shall act on the aid and advice of Council of Ministers. Next, the President may ask them to reconsider their decision, which becomes binding on them if it is sent for the second time. So what is the difference between President and his Council of Ministers versus Governor and his Council of Ministers? First, President is constitutionally obligated, compulsorily must act, the Honorable President ma'am, must act on the advice of Council of Ministers if it is sent for the second time. There is no such constitutional compulsion on the governor even if it is sent for the second time. First point. Second, the president has an implied discretion. President doesn't have a written discretion, situational discretion, that is implied, but the governor has a explicit discretion mentioned in Article 163 of the Constitution. Again, this is a half an hour topic, 1 or 2 points I will add and then immediately I'll turn into second topic. Jaise, for example, on 27th May 1964, Nehru ji suddenly died. On 10th and 11th January night 1966, Lal Bahadur Shastri ji died. So in those situations, the president appointed prime minister at his discretion, because the office of prime minister cannot remain empty even for a single day. If there is a probable choice, then the president has to appoint that person. Jaise on 31st October 1984, unfortunately, Mrs. Gandhi was assassinated. So immediately Rajiv Gandhi ji was administered oath of office. In that case, the president was not having a discretion. Otherwise, in those situations where the legislature party will meet and they will choose a prime minister, till that time the president appointed Gulzari Lal Nanda ji as the prime minister 2 times. First on 27th May 1964, second on 10th, 11th January intervening night when we lost Shastri ji. Okay, so this is an important. So president doesn't have an explicit discretion but has an implied discretion. In 1996 Lok Sabha election, nobody was having majority. So President Shankar Dayal Sharma ji invited Vajpayee ji to take oath as the prime minister because BJP was the single largest party. There the president employed his discretion. Governor, when the governor is expected to act in discretion, pure prelims question. 1, recommending president rule. No council of minister will recommend the president to dismiss themselves only by imposing president rule request to the president. So while recommending president rule, governor will act in discretion. Second, this we read in college as part of law, whether a prosecution should be started in a matter of corruption against a minister or not. This governor will act in discretion, not on the advice of council of ministers, because no council of ministers will advise to start a prosecution case against one of their minister. Here they will act in discretion. Third, reserving a bill for the consideration of president, governor will act in discretion. So if a bill that endangers the position of High Court against the principles of constitution or is against directive principle, all these matters governor has a discretion. Otherwise, just an important statement, in general, constitutional morality says 4th July 2018, Government of NCT of Delhi versus Union of India. An elected government should be respected. In general, the governor must act on the aid and advice of Council of Ministers. Otherwise, there is no point having a Council of Ministers that has majority in state legislative assembly. So in general, governor must act on the aid and advice of Council of Ministers. Otherwise, it will be against constitutional morality. Otherwise, when the governor feels that he must act in discretion, then he should act in discretion. This is the concluding thing. So this statement is wrong because there is no such statement mentioned in Constitution. This statement is also, Office of Governor doesn't prepare, so this is also wrong. So how many statements are not correct? So we'll settle for only 2. Only 2, that is B. So question number 13, I'll settle for only 2. Okay. This statement also we have gone for D, and here also we have gone for D. Next question is 14. Okay. Now this is a factual question. Center-state relation remains very important. Center-state relation starts from Article 245 of the Constitution. What are the 5-6 dimensions of center-state relation? Legislative relation, executive relation, and financial relation. Then you have national emergency, president rule, and financial emergency. 6 ho gaya. Then you have interstate water dispute. You have Niti Aayog, and you have interstate council. Article 262 interstate council, 263 interstate, 263 interstate council, 262 interstate water dispute, and then you have Niti Aayog, 1st January 2015 through a cabinet resolution. So you will go cooperative federalism, competitive federalism, both are mentioned on Niti Aayog website. UPSC has drafted a question directly from the website of Niti Aayog. Okay, that is competitive federalism, cooperative federalism which they have asked. So what are the various dimensions of center-state relation? I'm again saying legislative relation, executive relation, financial relation, national emergency, president rule, and financial emergency. 6. Then you have Article 262, that is interstate water dispute, and Article 263, that is interstate council. Then cabinet resolution, Niti Aayog. These are the major dimensions. One more aspect of what is the link that joins center and state? The link that joins center and state is governor. So the office of governor is also important from the perspective of federalism, and there can be a question. You just see the question paper, whatever we are discussing, they will hover around this because this is current affairs, this is common sense. So Raj Mannar committee was center-state relationship. Okay, this statement is correct. Justice G. Rohini Commission, you know, Article 340 of the Constitution, 2nd October 2017, submitted its report last year, subcategorization of OBCs. The report is not in public, okay? And what is the difference between Article 338B, that is a permanent commission, National Commission for Backward Classes, and Article 340 is temporary commission. Under Article 340, only 3 commissions have been established till date. Kaka Kalekar Commission, getting my point. Then you have BP Mandal Commission, 1st January 1979, Kalekar Commission 1953, and 2nd October 2017, that is Justice G. Rohini Commission. So Article 340 is a temporary commission. Only 3 such commissions have been constituted till date. Article 338B is a permanent commission that is there throughout the year. That is National Commission for Backward Classes. Never get confused between Backward Classes Commission and National Commission for Backward Classes. National Commission for Backward Classes is a permanent body which generally looks into the safeguard for backward classes. Backward Classes Commission under Article 340 is a temporary body. Whenever it is constituted, एक काम दिया जाता है, सिर्फ वही काम करते हैं. It is given a task, does that task, it is dismantled. So 3rd Backward Classes Commission was given the task of subcategorization of OBCs. 2nd Backward Classes Commission was given the task of implementing reservation for OBCs. 1st Backward Classes Kaka Kalekar Commission, general provisions related to backward classes and reservation in India. So you will never get confused between a Backward Classes Commission under Article 340, which is constituted time to time. It is temporary and it has only been constituted 3 times since the history of republicanism, that is 1950. But National Commission for Backward Classes, made a constitutional body by 102nd Constitutional Amendment. It is a permanent body. In general, it looks into over and under inclusion. In general, the safeguards related to National Commission for Backward Classes communities. Just to add, Article 339, there is a temporary tribal commission. 2 such commissions have been constituted till date. UN Debhar Commission 1960 and Dilip Singh Bhuria Commission 2002. So under Article 339, there is a temporary commission for tribal well-being. Under Article 338A, there is a permanent National Commission for Scheduled Tribe. So never get confused between National Commission for Scheduled Tribe, that is a permanent body under Article 338A, versus a temporary commission under Article 339. That is only 2 such commissions have been constituted. UN Debhar Commission and you have Dilip Singh Bhuria. So now you see, and there is one more tribal commission that is mentioned in the 6th schedule. Okay, that also has to be visited. UPSC may ask that question. Okay, so we have a Raj Mannar committee. This is correct. Center State Fiscal. G. Rohini, this is wrong because OBC categorization. Justice Mula committee, prison reform. So what they have done, they have crossed. So this will eliminate. Ranganath Mishra, religious and linguistic minorities. 1st and 4th is right. I will easily settle for option B for Bombay. Just an addition. What is the difference between commission and committee? Nowhere it is mentioned in difference. Neither it is mentioned in Article 366 of the Constitution that has all the definitions. Article 366 में सारा definition clause है वो. Okay. So there is no definition. General Clauses Act 1897 has all the definitions. So commission and committee definition is not mentioned in the constitution, but in general 3 aspects are given. One, commission is usually constituted by a constitutional or a statutory provision. Although there are some exceptions also. National Commission for Backward Class, Article 338B, National Commission for Scheduled Tribe 338A, National Commission for Scheduled Caste, Article 338, Election Commission of India, Article 324, Finance Commission, Article 280. So usually commissions are created by the Constitution or Protection of Human Rights Act, National Human Rights Commission, Central Vigilance Commission Act, Central Vigilance Commission. So usually commissions are created either by the Constitution or by a statute. Committees are most in the entire Constitution I found only one committee. Pure from 1 to 395, Article 344, Official Languages Committee. That has one official language commission also and official language committee also. So in Article 344 of the Constitution. The only parliamentary committee that is mentioned in the Constitution. There is no parliamentary committee mentioned in the Constitution other than official language committee, that is in Article 344 of the Constitution. Second big difference which most of the scholars agree between a commission and a committee. Committee usually may or may not have inquiry powers or investigative powers, but commission always have powers of inquiry and investigation. So inquiry is one of the mandate of the commission. Okay, I'll not go much into it. So we'll settle for B. 14B, I'm again running short of time. So next we have 15. We have 15. Now dear students, this was a question which has been taken from previous year's question paper. Again this is important. क्यों important है? बिल्किस बानो केस. Section 432 of CRPC, Section 433A of CRPC, Section 435 of CRPC. Section 432 of CRPC, appropriate government will make remission rules. Section 433A of CRPC. Now this is complicated. Any person who has committed an offense where one of the punishment is death, if he is given life imprisonment, then he will not be released before 14 years. Just for an example, if you commit an offense, आपने कोई offense किया, if you commit an offense where the maximum punishment was death, death was one of the punishment, but you were not given death, you were given life imprisonment, then you will not be released before 14 years. Otherwise it will be injustice. First, so you should have been given death, but they didn't give you death, they gave you life imprisonment, and now you are released after 2 years. It will be injustice. So those people who may have been given death in simple language, but they were not given death, they were given life imprisonment, then they will not be released before the expiry of 14 years. This is a proviso, this is a caveat, Section 433A of the CRPC, old CRPC. Section 435 of CRPC, कभी भी स्टेट गवर्नमेंट किसी को रिलीज करेगी, I'll repeat in English also, don't worry, किसी भी स्टेट गवर्नमेंट किसी को रिलीज करेगी कोई भी ऐसे मामले में जिसकी सेंट्रल एजेंसी ने इन्वेस्टिगेशन किया था, तो बिना सेंटर को कंसल्ट किए ऐसा नहीं किया जाएगा. Whenever a person will be given remission where the investigation was done by an agency of the union or an agency under Delhi Special Police Establishment Act, you know which agency, CBI, then in that case center will also be consulted before the release of that person. So Section 432 of CRPC, the state appropriate government will make remission rules. Section 433A of CRPC, life imprisonment walon ko will not be released before 14 years. And Section 435, if the state government wants to release someone in a case where investigation was done by the union, then the state government will also consult the central government. I'm not going into that case because it will take ample of time. Let's go to this question, which says, which among the following envisages a short-term temporary release of a prisoner without any reason after a stipulated number of years have been served in prison, although the prison does not have an absolute legal right? Answer should be follow. Why? Other we'll discuss. Reprieve, what is reprieve? A temporary, what is reprieve? Reason? Getting my point? A temporary stay on the execution of a sentence, generally a death sentence, to give the person a time to file for a remission. Okay. If you'll go to the website of official website of President of India, then what you call, then you will find mercy petitions ka wahan ek column hai. There is a column of mercy petitions. This itself again is a topic, but I'll very briefly touch because I know that many things you don't know. Pehla, you will never get confused between Article 72, 161 versus 432, 433A and 435. Generally, जो लाखों लाख prisoners हैं इंडिया में, there are lakhs of prisoners or thousands, whatever prisoners are there in India, generally remission is not given under 72 and 161. Generally, people are released in a periodical manner, that is under CRPC. So most of the remission in India is done under CRPC. Very rarely Council of Ministers advise, usually on a death matter, that is Article 72 and 161. Recently Supreme Court said that the powers under 72 and 161 are vast because they are constitutional powers. It should not be compared with 432, 433 and 435, which is statutory power. Second, debate about death penalty in India, that is mostly a mains topic. They have asked in 2014 mains mein they have asked this question. 14 or 15 mains mein they have asked this question. Third, that what are the 5 key terms that you know, that you have pardon, then you have commutation, then you have respite, and then you have reprieve, and then you have remission. So pardon means complete absolvement. It can save you from conviction, it can save you from disqualification, and it can also save you from sentencing. You are found guilty, that is conviction. Then you are given punishment, that is sentencing. For example, you beat someone, but you are convicted when you turn 92 or 93. So in that case, you are 93 years old, court will say, okay, I find you guilty, you are convicted, but I will not sentence you, I will forgive you. So you are convicted, but not sentenced. So there is a difference between conviction and sentencing. And disqualification. For example, court forgives you, but still you cannot contest election because although you are not sentenced, but still you are convicted, so you are disqualified. Pardon can save you from all the things. It can save you from conviction also, it can save you from sentencing also, it can save you from any disqualification that is arising due to a conviction. So here there are 4 key terms. Reprieve, that is temporary stay is there for you to file a petition, mercy and all. Parole is discretion. Follow में level of discretion कम है. Parole, follow में not necessarily a reason is given. Parole में it is given. What is follow? You will be surprised that there is a service in Bihar probation service. Probation, their job is, what is their job? Their job is to look into remission. For remission, there is a special service in Bihar, like you have Bihar Administrative Service, Bihar Police Service, Bihar Finance Service, Bihar Revenue Service, Bihar Welfare Service. Also, there is a Bihar Probation Service. ये officers क्या करते हैं? They look into remission. All the convicts that apply for remission, they go to their house, prepare a secret report that under what conditions they committed this offense, whether they should be released on parole or follow. Follow, generally, when a prisoner is there in jail for a long period of time, then there is a monotony. Matlab he becomes monotonous, so he is released for a particular period of time. Reason may not be necessary there. He is released, and generally follow is given. Generally follow is given, but parole there is a strong reason. Generally follow is in long sentences, where you are in jail for long years, then you are released in between. Follow is earned by your good behavior, by your days in jail. It is a friend of mine who is in probation service, he said कि jail में there are 24 days. बोला we count 24 days as a month. In jail also they are given holiday. And although for example, somebody is given 2 years of imprisonment. So 2 years doesn't mean 2 years. I also didn't knew this. He only explained me. 2 years doesn't mean 2 years. 2 years means every month will be counted only in 24 days. So they will be given 6 days of leave. So इसी तरह there are other leaves that you earn, that you use in the form of follow. But parole is usually when someone dies in the family, sister's marriage, then it is given. Parole में there is large element of discretion. Follow is usually granted in a conventional manner. There is less element of discretion. Now you see here, which among the following envisages a short-term temporary release of a prisoner? Till here it can be parole also, it can be. Till here it can be parole also, it can be follow. Without any reason. Again, parole requires a reason. तो यहाँ तो कट गया. After a stipulated number of years have been served, although the prisoner does not have an absolute right. Always remember, if you go through last question paper, whenever UPSC uses an extreme situation, it is saying that there is no absolute right. You must understand, in the world there is nothing which is absolute. I have 5 fingers, including thumb. Hrithik Roshan has 6. So always there is an exception. So जब भी UPSC ये कह रही है, there is no Article 17 untouchability चलिए, it is to a large extent it is absolute. Otherwise always you will find an element of. So if UPSC is saying it is not absolute, it is actually a correct thing, because things cannot be absolute. There will be some or the other restriction. So reprieve, though it is like when you file an appeal, it has nothing. Respite, and less sentence is given due to a health condition, maybe pregnancy, visually impaired, or anything, God bless. So matlab physical disability, anything. So respite and reprieve will parole nahi, so we will settle for follow. That is option C. 15 option C. So we are a bit slow. 16 we have, now this is an easy question. This may I will not explain much. 2 things you need to remember bas. Pehla, Rules of Article 118 of the Constitution allows both the houses of Parliament to make rules for their functioning. Article 118 of the Constitution allows both the houses of Parliament to make rules for their functioning. Everything cannot be written in the Constitution. Constitution allows both the houses of Parliament. दोनों हाउस को अलाउ करता है कि अपनी फंक्शनिंग के लिए रूल बना सकते हैं. Both the houses of Parliament can make rules for their functioning. Rules of procedure and conduct of business Lok Sabha. Rules of procedure and conduct of business Raj Sabha. So Article 118. Now, of course, you don't need to see rules. I always show them rules. There are some students from the class, you know, I always show them rules. You don't need to go through the entire rules because it is sheer waste of time unless you are attempting prelims in 2061. So you don't need to go through those rules. Okay. Only thing is, all the terms that are mentioned in the book that you are referring, if you are referring Vision ABHYAAS material or you are referring Lakshmikant, I strongly recommend the words that are mentioned in 5-7 terms are there, which are mentioned in the book. Those terms you will not read from the book, you will read from the rules directly. Then you will have it is just a small 2-3 line paragraph. It will give a next level understanding. So download the rules. Don't read the rules. It will take 5 to 7 minutes. No confidence motion, adjournment motion, all these key terms which are mentioned in the, especially the parliamentary, what you call devices, you may go through. जैसे rule 204, presentation of budget. जैसे अभी no confidence motion आया था सरकार के खिलाफ. No confidence motion was rule 198 of Lok Sabha. No confidence motion. जैसे UPSC has asked this question last year in prelims. According to the rules of procedure and conduct of business of Lok Sabha, the speaker is, date of election of speaker is decided by the president. This is rule 7 of Lok Sabha. So UPSC has already asked. I am not speaking in blank. Okay. So those, जैसे rule 7 of Lok Sabha, rule 8, rule 7 UPSC has already asked. Rule 198, no confidence motion. Rule 204, presentation of budget. So those things that are mentioned in the Lakshmikant or Vision ABHYAAS material, those you can read from the primary text. Rules क्या है, सब कुछ constitution में नहीं लिखा जा सकता है. Everything cannot be written in the constitution, so they have to be mentioned in the rules. And two more things. If any state legislative assembly doesn't have a rule on any particular matter, it follows the rules of Lok Sabha. This question can also be asked कि किसी भी state legislative assembly के किसी मुद्दे पे अपना rule नहीं होता है तो वो follow करती है rule of Lok Sabha. So it follows the rules of Lok Sabha. And there was a law which was passed in March 2021. The Legislative Assembly of Delhi that shall not make any rule that will be inconsistent with the rules of Lok Sabha. No rule of Legislative Assembly of Delhi shall be inconsistent with the rules of, this was added in Government of NCT of Delhi Act 1991 by an amendment in March 2021. Okay. So now what is naming a member? When naming a member means when a member is disregarding the chair, when the member is creating unruly scene, then the member will be asked to leave the house. That can be for the remainder of the session also. Okay. So this is something we have what you call Rule 256 of Raj Sabha and Rule 374 of Lok Sabha. Rule 256 of Raj Sabha and 374 of Lok Sabha. कोई misbehave कर रहा है, he will naming a member मतलब उनका नाम ले लिया, अब उनको बाहर जाना है. They have to go out, they cannot participate in the meetings of parliament, they cannot participate in the meetings of committees also. Many opposition MPs were suspended, so that is why this question has been incorporated. So dear student, what should be the answer? In context of Indian Parliament, term naming a member refers to it is a time of pecuniary punishment, monetary punishment. Pecuniary word on Google means anything related to money. So this is not a monetary. That is not a monetary punishment. Only at one place I have found monetary punishment mentioned in the Constitution. Any member who sits in the house without taking oath, knowing that he will not. Otherwise, monetary punishment is usually not mentioned in the Constitution. ये तो पहले ही चला गया. Immediately after question R, it has nothing to do with question R. A member against whom comments or criticism of personal nature are made with the consent of chairman, a personal explanation in his defense. There is no such thing. So the only answer would be the chairman alerts the house to a member's misconduct, aiming to suspend them from service for disregarding the chair's authority or janbooch ke, willfully obstructing the house business. This will be naming the member. So 16 we will settle for D for Delhi. Okay, 16 will settle for D for Delhi. 17. Let's see. Now this is an easy thing. This is such a beautiful question. It has come from Article 67. It has come from Article 67. Anyone who will read Lakshmikant will make, I'll tell you, it is a wonderful book. I am nobody to deny the book. It is a wonderful book, but it is a notes. At the end of the day, it gives you information about that constitutional body, functions and everything. It is not going to help you in prelims as well. It will give you a very solid understanding of the basic. बहुत अच्छी book है. पूरा constitution you will understand, but you will not be able to answer questions, because UPSC is asking about Indian Prisons Act, UPSC is asking how France can learn from Indian secularism, UPSC is asking what is, wo aap usse jawab, you will have a very good understanding of the constitution, you will feel confident also, lagega lagne laga hai par lagega nahi. Getting my point? So you will feel confident also, but you will make mistake in the examination hall because they are not asking question from Lakshmikant. Honestly, why will I say anything? It's such a wonderful book. Many years back, I have also read. I respect the book, but I would say one line: it is not enough, and that I can write with my blood. It is not enough because you just go through the questions of last 3 years, then you see the questions that have been asked. It is not enough. Okay, so because they are not asking questions, they are asking Indian Prisons Act, they are asking Official Secrets Act. Getting my point? They're asking what you call this question related to payroll. They're asking question related to follow. They're asking question related to judicial custody. They're asking question related to police custody. Show me. They're asking what France can learn from Indian secularism. They're asking a question, what are the cultural practices? Our cultural practices are being challenged in the name of secularism. Show me all these things in Lakshmikant. Getting my point? So they are asking, ab Lakshmikant, they have given pocket veto, absolute veto. UPSC is asking the term pocket veto, they will ask tomorrow. According to the Constitution of India, Attorney General resigns. So Lakshmikant will give you a solid understanding of the Constitution, but just the basic understanding. You have to add that with those things which you read in Lakshmikant which are important. Then you can add that from the Constitution. Few articles which are there in the Constitution, and most importantly, emphasize on current affairs. Okay, because that book itself is not enough. That's a wonderful book, but not enough. So, which of the now why this whole thing I said? Article 67 of the Constitution says the Vice President will be removed by a resolution supported by the then members of the House. Language of the Constitution देखिए. If they will ask a question, it will be assassination. वहां लिख दिया. They have written Vice President will be removed by a resolution supported by the then members of the House and agreed to by Lok Sabha. बस इतना ही लिखा है कॉन्स्टिट्यूशन में. वाइस प्रेसिडेंट विल बी रिमूव्ड बाय अ रेजोल्यूशन, ऑल्दो 14 days notice, all such, just leave that. Just prime point that I want to emphasize. A resolution to remove vice president will be introduced in Raj Sabha and will be supported by the then members of the House and agreed to by Lok Sabha. Then members of the House, scholars interpret it as effective majority. Scholars interpret it as effective majority. Ab in the book they have written special majority, because there is a common thinking that any majority that is not simple is a special majority. But the technical term would be effective majority. Although in Lakshmikant they have used the term impeachment for judges. The Constitution never uses the term impeachment for anybody other than President. In Article 61 they have used the term impeachment for President. In all other articles they have used the term removal. So, and there are places where they, minor changes are there. But anyways, I'm not going into that because at the end of the day, it's a very good book for basic understanding. Okay. So the point, because least errors are there, because so it's good. Although the Judges Inquiries Act, Judges E and Q U R Y, they have written I and Q. I means asking a question, whether the train will leave at 7 or 8. E means inquiring into something. So these are not, they are just kidding on, these are not important. But what is important, ki how Vice President is removed. This is a pure prelims question to trap you. How Vice President is removed? Constitution says Vice President is removed by a majority of then members of the, bas yahi likha hai Constitution, only this thing, by a then members of the House and agreed to by Lok Sabha. So then members of the House means effective majority in Raj Sabha and simple majority in Lok Sabha. Agreed to by Lok Sabha ka matlab hai simple majority. Then members of the House means, if what is effective majority? Whatever is the total membership of the House. If the full strength of the House is 100 minus vacancy. Vacancy means, doesn't mean those people have not come on that day. Vacancy means ki itni seats khali hain. These seats are vacant because of death, resignation, disqualification, election setting aside, any reason. For example, total strength of the House is 100. 10 seats are vacant due to death. So the effective strength would be 90. Majority of 90 is called as effective majority, irrespective of the fact that who came on that day. Even if 60 people came on that day, it doesn't matter. Whatever is the effective strength of the House, uski majority. So total membership of the House minus vacancy, not absenteeism, vacancy. How many seats are vacant? That is effective strength of the House. Effective strength ki jo majority hui, that is effective majority. So Vice President is removed by an Vice President is the only constitutional dignitary that is removed by two different majorities in two different houses. In Raj Sabha you require effective majority, in Lok Sabha you require simple majority. He's the only constitutional dignitary. I don't want to stretch because this is an important. You read Article 67, you will get an answer. In which of the following cases Rajya Sabha has more powers than Lok Sabha? Constitution Amendment Bill, they have equal powers. Money Bill, Lok Sabha has more powers. Article 109 and 110, both. Election of President, Article 54, they both have equal power. Removal of Vice President, Article 67, Rajya Sabha has more powers, because removal of Vice President cannot be initiated in Lok Sabha, it can only be initiated in Rajya Sabha. Pehla. Second, you require effective majority in Rajya Sabha, but you require simple majority in Lok Sabha. So both ways, who is more powerful? Rajya Sabha is more powerful, so easily we will settle for 17 ka D. But effective majority term is not mentioned there. They have mentioned the term by the then members of the House. Then members of the House means effective majority. Samajh rahe? So 17D. Now we have 18. 18 with respect, now this question, maximum students have committed mistake in this question. Maximum students have committed mistakes in this question. We were going through, we have a chart now, we have statistical empirical data. Specifically, this question has been highlighted. Most of you have made mistakes on this. I know, first I read the question number, then I went to the question. I immediately got an answer. Because this is a question which is not given in Lakshmikant. This is a question which is not given in printed material. They have mentioned Vineet Narayan case, if you have read carefully. So in Lakshmikant, this is not mentioned, or standard textbook DD Basu and all this question, this is not mentioned. Isliye you made mistake. Iska matlab hai, anything that is asked beyond the text, you will make mistake. It means that 75 is the right cutoff. It means that 75 is the right cutoff. Okay. So why this question? First I was highlighted that most of the students have made mistakes in this, and second I went and so I got an answer. I don't need to be explained, because this is something which is practically, if you will answer newspaper well, read newspaper well, you will get this answer correctly. Every year, this, if you see this question number, and there is every time you will read ki Haryana mein recently 2 state mein DGPs were appointed and discussion was going on. One Haryana, one Maharashtra. Isse pehle UP mein bhi issue was going on. DGP was given extension or whatever. So whenever in Bihar also DGP was appointed. So this question is not factually given at one place. This question is an ongoing product of the newspaper that you read, that UPSC is deeply involved in appointment of DGP. It sets the norms and the instructions, and the names are sent, and then panel of names are sent. Pehle tha, 2 change hua hai. DGP badi post hai na ji. DGP is a big post, so he has to given a certain security of tenure. If you will become DGP and you will retire in 2 days, then how will you? So nobody whose no name will be sent for DGP, a person who has less than 6 months of service. If you have less than 6 months of service, your name will not be sent for. Second, pehle tha, to become DGP, you have to have at least 30 years of service. So anybody who joined after 30 will never become. Anyone who joined after 30 will never become DGP. Usko unhone reduce karke 25 kar diya hai. They have reduced that too. So even if you have 25 years of service, you will be eligible for becoming DGP. Names and all are sent by UPSC. In fact, ek provision hai. Whenever an action is taken against a servant, ab is pe 2-3 point. 1, if you are recruited on the recommendation of UPSC, throughout life, whenever a disciplinary action will be taken against you, UPSC will be consulted. This I personally know, that if a state public service commission is to be punished by the state government, state public service commission will be consulted, on whose recommendation that public servant was appointed. If an IS IPS officer is involved in a misconduct, UPSC is consulted before. Although Supreme Court has ruled that conventionally UPSC is consulted, but not consulting UPSC will not be a ground to challenge that punishment. That is not compulsory, but usually they are consulted. One thing. Second important thing, whenever a state PSC officer is promoted to IAS or IPS, then also names are sent by the scrutinized, and everything is done by the UPSC. So that is UPSC is involved. And in DGP's appointment also UPSC. Prakash Singh Badal case and Vineet Narayan case, these are the 2 important cases. So Union Public Service Commission sets the guidelines for empanelment of officers as appointed at state DGP. This is absolutely a correct statement, because UPSC is deeply involved. Recent guidelines, only officers with at least 6 months of service left before retirement for DGP. This is also a correct statement. And recent guidelines have reduced the minimum experience from 30 years to 25 years. Ek aur raz ki baat. It is not that the state who is promoted to IAS, BAS or UPPCS nahi, sab promote hote hai IAS mein. Not only Bihar Administrative Service will become IAS. I know officers from Bihar Engineering Service become IAS. Last year, there are 10 or 12 people from Bihar Finance Service became IAS. So from state PCS, not only from state administrative service people become IAS, they also become IAS from state engineering services, state education service, state health service, state other services. Because I तो personally I know Bihar engineering service के DC थे बिहार में. Engineering service तो 2 officers I know who were promoted to IAS from state engineering service, and state 10 or 12 people from finance service were promoted into IAS. So it is not that the state PSC में only administrative service officers are promoted to IAS, other services are also promoted to IAS, but undoubtedly majority of them are from state administrative service, but it doesn't mean that other, and all these things are also done by UPSC. Okay, so UPSC is not consulted on 3 matters. 1, matters of reservation. 2nd, when there is a diplomatic appointment. 3rd, when there is an appointment which is up to 1 year. So 1 year, matters of reservation and diplomatic appointment, UPSC is not consulted. Otherwise, UPSC is always consulted. All 3 statements are correct. We'll settle for option C for Calcutta in question number 18. Okay, now we will, question number 19. Let's see. Now this is a very easy factual question. This is just go through 106 Constitutional Amendment Act, Article 330 capital letter A and Article 332 capital letter A. Article 330 capital letter A and Article 332 capital letter A. Babu, 330 capital letter A, reservation for seats in women in Lok Sabha, and Article 332 capital letter A, reservation of seats for women in State Legislative Assembly. Why? That is also a reason. Article 330, seats are reserved for SC/ST in Lok Sabha in proportion to their population. So there only they added 330 capital letter A, seats are reserved for women in Lok Sabha. Article 332A, seats are reserved for SC/ST in State Legislative Assembly as per their population. Article 332A, seats are reserved for women in State Legislative Assembly. So where there was reservation for SC/ST 330, they have added it for A, and where there are reservation in State Legislative Assembly, they have added it for women. But this is an incomplete statement. 5 more facts are there. Pehla, there is no reservation for anyone on the basis of caste in Rajya Sabha except 12 nominated members. Pehla. Second, there is no reservation for anybody on the basis of caste in State Legislative Council, Article 169 of the Constitution. So 2 things you remember: caste-based reservation is not there in Rajya Sabha nor in State Legislative Council. Second point. Third, most important point: never get confused between reservation in public employment, reservation in educational institutions versus reservation in Lok Sabha and State Legislative Assemblies. Never ever. Reservation in educational institution, IIT Delhi, Central University of Hyderabad, University of Delhi, or for that matter, you have a National Institute of Fashion Technology or Indian Institute of Management. All these reservations are covered under Article 15 Clause 5. Reservation in public employment is covered under Article 16 Clause 4. Reservation in Lok Sabha is covered under Article 330 and State Legislative Assembly under Article 332. There is a fundamental distinction between all these. Under Article 15 and 16, years are not written for 10 years and also. In our Article 334, this 330 and 332 was for 10 years, which has been extended every 10 years. And the most important thing, under Article 330 and 332, reservation is given as per their population. So in Article 15 and 16, reservation is not given as per their population. 52% OBC population is there as per the caste census, last caste census, which was in 1931. Mandal Commission has said that 3,743 caste can be said to be OBC, and they constitute approximately 52% of population. Caste census has not been conducted in India. Last time it was conducted in 1931. Only one state, that is United States of Bihar, that has conducted a caste census that is called as caste survey. Otherwise, the last caste data that we have is of 1931. SC/ST as per Census Act 1948, the 10 years that we do census, we have SC/ST data and unreserved data. We don't have caste data. Last caste data for the entire country that we have is of 1931. State of Bihar conducted its own caste survey, so they have their caste data. Otherwise, caste census was last time conducted in 1931. Mandal Commission relied upon 1931 data and mentioned that 3,743 caste can be said to be OBC. They constitute 52% of population. But reservation is 27%. So in Article 15 and 16, there is no, although inadequate representation is mentioned over there, but population ke ekdam barabar hoga aisa mention nahi hai. They are equal to population, not mentioned. But in Article 332, seats will be reserved for SC/ST in State Legislative Assembly as per their population. So our brothers and sisters from Arunachal Pradesh, 59 out of 60 seats are reserved for scheduled tribe. And the State Legislative Assembly of Arunachal Pradesh, 59 out of 60. Why? Because seats will be reserved for SC/ST in proportion of their population, and that is a great justice. You cannot have people in State Legislative Assembly who are not from that place. So that is why seats are reserved for ST. 59 out of 60 seats are reserved for scheduled tribe. So never get confused between reservation under Article 330, 332 versus 15 and 16. So let's see, recently Parliament passed 106th Amendment Act to provide for 1/3 reservation for women. This women reservation is, so dear students, Raj Sabha, so there is no caste based reservation. You have, and you must read Article 79 to 82. Article 79, there shall be a Parliament of India consisting of Council of States, House of People and President. Article 80, 81 and 82 related to delimitation, and Article 329 clause 1 related to. These all articles are likely to be asked this year because of new Parliament construction, and this I was also mentioning there. Anyways, there is no caste-based reservation in Raj Sabha. Only 12 members up to 12 can be nominated. There is no caste-based reservation in State Legislative Council. Women reservation has been provided under Article 330A and 332A in Lok Sabha and State Legislative Assembly. So answer would be 2 and 3. So I'll settle for 19 ka C. For more information, refer Article 330 to 334. Okay, please go through that. Now we have 19, next is 20. Okay, let's see 20. Okay, with reference to the Chief Election Commissioner and other election commissioners are consider the following statement. Article 324 of the Constitution, there shall be an Election Commission of India. Getting my point? Article 324. Election Commission of India for direction, superintendence and control. This is the language of the Constitution. Direction, superintendence and control to the elections to the Parliament, State Legislature, President and Vice President. So which all elections are conducted by the Election Commission of India? Which all elections? Which all? Office of Speaker? No. Office of Deputy Speaker? No. Only 4 elections. President, Vice President, Parliament and State Legislature. Where? Article 324. Okay. It is a lot, but I will not, we have running short of time. So this new law has been passed. Chief Justice of India, the Supreme Court ruled that Chief Justice of India will also be part of the committee. Chief Justice of India will also be part of the committee. They will choose the next Chief Election Commissioner or Election Commissioners. But the Parliament passed the law where they excluded the Honorable Chief Justice of India. So as per the new law passed, Prime Minister shall appoint the Chief Election Commissioner and other election commissioners. Nahi. Article 324 of the Constitution, the Chief Election Commissioner and the other election commissioners, if any, shall be appointed by the President. So this is a wrong statement. Selection Committee consisting of Chief Justice of India, no, this has been excluded, wrong. CEC and ECs are not eligible for re-employment. This is a correct statement. Yes, they are not eligible for re-appointment. Acha, one more thing. A member of UPSC cannot take a post under Government of India after retiring. Comptroller and Auditor General cannot take a post under Government of India after retiring, but they can become governor. Paul sir was Delhi Police Commissioner, then he became the member of UPSC and then he was appointed as governor. So office of governor is not an employment under Government of India. So a member of UPSC and State Public Service Commission cannot take a post under government, but they can take constitutional post only under Lokpal and Lokayukt Act. It is written that any person who become Lokpal and Lokayukt, they will not contest any election from president to what councillor for 5 years. यही एक लॉ है जहां कोई भी इंसान जो लोकपाल बनेगा या मेंबर, वो प्रेसिडेंट के इलेक्शंस लिखा हुआ है फ्रॉम प्रेसिडेंट टू अ मेंबर ऑफ म्युनिसिपैलिटी, सारे ऑफिसर्स कोई भी इलेक्शन नहीं लड़ सकते हैं, वो 5 year कूलिंग ऑफ पीरियड है. आई एम जस्ट डिविएटिंग little bit, coming back to this. So these things are there so that they provide safeguard to their office. As a safeguard hota hai, sub security is provided so that they function in a more independent manner. Now dear students, CC and other ECs are not eligible for reappointment. Can they be appointed or under Government of India? They cannot be reappointed, okay, but they can take a political post and they have also become ministers also. ऐसा कुछ नहीं. And members of UPSC and chairman of UPSC, they are not eligible. Chairman cannot be what you call reappointed as the chairman, okay. Although a member can have a separate tenure as the chairman or hai bhi, abhi honorable member has become chairman, but you must always remember that they are not allowed to take any post under Government of India. But the post of governor is not a post under Government of India, it is a constitutional post. Comptroller and Auditor General after retirement also cannot take a post under Government of India. So one statement is correct, this, so we'll settle for 19A. 19, what you call, which question? 20, hai na? So 20 we will settle for A. ये स्टेटमेंट गलत है, ये स्टेटमेंट इज रॉन्ग, दिस स्टेटमेंट इज रॉन्ग बिकॉज हियर इट शुड बी प्रेसिडेंट, हियर इट शुड नॉट बी चीफ जस्टिस ऑफ इंडिया, दिस स्टेटमेंट इज करेक्ट, सो आई विल सेटल फॉर 20 का ए, दैट इज ओनली 1. ओके, नेक्स्ट क्वेश्चन वी हैव क्वेश्चन नंबर 38. ओके, now we have to be a bit fast. Okay, these are factual questions. Okay, then we have 38 and 39. Okay, let's see. Now dear students, this is an easy question. Pradhan Mantri Matru Vandana Yojana. Okay, the scheme provides cash incentive to all mothers who give first live birth and second live birth only if it is a girl child. Absolutely correct statement. First live birth में irrespective of gender पैसा मिलेगा, you'll get money irrespective of gender. Second only if it is a girl child. Then the scheme seeks to discourage pre-birth sex selection. This is a general statement which can be taken, so we will easily settle for C for Calcutta. अब अगर आप इसमें थोड़ा और the kind of question that UPSC is asking, 2 laws if you get time you can study. One law is Maternity Benefit Act, which is very very important. Second is Preconception Prenatal Diagnostic Techniques Act 1994. थोड़ा सा देख लीजिएगा. Not the law, sections में नहीं बोला. I'm not asking what is the sex-based selection, feticide, infanticide, all such things. So how it is banned in India? You go to a ultrasound center, लिखा रहता है Preconception Prenatal Diagnostic Techniques Act. Preconception PC, prenatal PN, इसको कहते हैं PCPNDT. Okay, Preconception Prenatal Diagnostic Techniques Act 1994. I'm not asking you to go through the sections, but what is the position of the law? Whether the law has been able to bring some change in the ground. What are the important sections of the law? For means you can go through. Okay, this I'll settle for 38C. Next is 39. 39, let me read. With reference to Asha, Anganwadi and auxiliary midwife. Okay, always remember, whenever this kind of questions are asked, what they will do, they will mix. They will mix. So UPSC has some, although we cannot say with certainty. I'm just giving you a hint. Whenever UPSC uses an absolute statement, most likely it is going to be a wrong statement. Usi tarah, whenever they will ask this kind of question, they will do nothing. What they will do, they will mix the fact. Asha ka Anganwadi mein, Anganwadi ka Asha mein. So that if you are not sure about the fact, you will get confused. Okay. So with reference to Asha, this is purely a factual thing, nothing to explain. If you know, else you will just guess. Akkad bakkad bambebo. Otherwise, with respect to Asha, Anganwadi and auxiliary nursing midwives, Anganwadi workers provide primary health care, assistance and offer community level curative assistance. Okay. So this actually is provided by Asha workers. Okay, associated social health activists are there, so they have just changed. Asha workers are voluntary workers, provide health checkup. This is done by Angan. जो आंगन में जा के उनके health को check करती हैं. Those who go to the Angan and then check their health, they are Anganwadi. So what they have done, they have changed this to this. So both the statements are wrong. The role of what you call with respect to this, the role of auxiliary nurse midwife is to provide healthcare access to non-communicable diseases. No, it is not that only on non-communicable diseases. So this is also a wrong statement. So we will settle for D. 39, D for Delhi. It is a matter of common concern that same kind of questions UPSC is asking time and again. See, always remember, exam is not tough, but the syllabus undoubtedly is vast. So why those students who have started from early, they will have an edge. Ekdam simple rule hai. If you will try to overcome time, there will be a race against time. Akshay Kumar. Okay. So getting the point, there will be a contest between you and time, and you will make a schedule that, okay, 7 days polity, 13 days physical geography, environment. You will make that time, but you will run short of time because there are assassinators who have done from last year June. Getting my, so exam is not that tough. Only thing is you start a bit late. So if you are using your time judiciously, you, of course. So all these facts, conventional areas, 50-60 hai, UPSC repeatedly is asking a question, Atal Pension Yojana, Asha, Anganwadi, auxiliary midwife. Wahi question, ghuma pera ke same, 14, 21, 25. Conceptual question they are asking from 14, 21, 25, secularism and judicial review. Wahi 5 topics mein ghuma pera ke and preamble. Conceptual question. So still if we don't do, then it is sheer, what you call, state of intellectual inertia. State of intellectual inertia. Okay. So I'll exclude all the 3 for 39. I'll settle for D for Delhi. Okay. We are running short of time. Okay. Then we have 51. Let's see. These are factual. Now this is an easy question, dear student. New look policy, Eisenhower, American. New look policy India में आपने सुना है? This is American. Look East policy, Narasimha Rao ji. Act East policy when Prime Minister went for Indo-ASEAN summit. He said, when Hillary Rodham Clinton came to India, she made an observation while she was addressing that the time has come for India to act rather than just look. When our Honorable Prime Minister went for Indo-ASEAN summit, he made a statement that the time has come for India to move from look to act. East. So act, and then when he went to Japan, initially Southeast Asia was there. Now Japan, South Korea, Mongolia, all these is a part of our Act East 2.0. So what is the difference between Look East and Act East? Act East is an extension of, and a scholar has said, Act East is an action-oriented, extended neighborhood policy that is a departure from, matlab, a progressive departure from Look East policy. Okay, so the term, although I read somewhere in ki bhai, this was actually used by Hillary Clinton, but it was not part of our policy. So we use, the Honorable Prime Minister used this term, that is Act East policy. You can also read RCEP, Regional Comprehensive Economic Partnership. Neighborhood first policy also, you know, when Prime Minister became the Prime Minister, first time when he took oath, he first went to Bhutan. Then he went to Nepal. Second time when he became Prime Minister, he went to Maldives. Getting my point? So the point is, all the time, what is neighborhood first policy? I.K. Gujral is also credited, but in the real sense, it is Prime Minister. So here they have taken it as for the present government. Neighborhood first policy is simple. We will exhibit magnanimity towards our neighbors and not expect something in reciprocity. We will exhibit magnanimity towards our neighbors, bada dil rakhna, but we will not expect something in reciprocity as long as their land is not used for anti-India activity. So that is neighborhood. Priority will be given to neighborhood, and that is reflection by Prime Minister calling the SAARC neighbors in oath ceremony in the first tenure, and BIMSTEC, Bay of Bengal Initiative of Multi-Sectoral Technical and Economic Cooperation, BIMSTEC leaders in what you call this second time when he took oath on 30th May. So the point is, कि यही है neighborhood first को we will go and extended neighborhood. Prime Minister goes and also said extended neighborhood and all this. Very interesting, very enticing. It's quite easy. So which of the following are PV Narasimha Rao ji's contribution to India's foreign policy? New look is an Eisenhower US president related to Russia and all. Act East is of course Prime Minister Modi ji. Neighborhood first policy is also there. So we will only settle for one. So we will two. So 51A only one. 51A only one. Next question is 52. 50 ये क्या है सुनिए. For example, in what you call India is a crucial link between underdeveloped, developing and developed countries. You all are intellectually sound to understand that India has emerged as the voice of the global south. I don't even need to say. In fact, India is also seen as a swing state. India is also seen as one of the most promising countries. US, Obama ji ne ek baat kahi thi. Obama ji said that the relationship between India and US shall be the defining partnership of 21st century, which I think UPSC also asked once. So the Indo-US relationship shall be the defining partnership of 21st century. So India is seen as the pivot to US South Asian foreign policy, and India also has an independent foreign policy without a shadow of doubt. So US wants a firm hand. US wants a tight embrace. We want a firm handshake. US wants a tight embrace. We want a firm handshake because we know that neighbors cannot be changed, but friends can be changed. So we do understand. So we do not exhibit too much of ye. Ab. In World Trade Organization ले लीजिए या Article 12 of Paris Climate Deal ले लीजिए. Intended nationally determined contributions, if you will see, or common but differentiated responsibility. Be it amber box or blue or green box subsidies in agriculture or agriculture ले लीजिए या Doha Climate Discourse. India has been the flag bearer of developing and underdeveloped countries. Since we got the opportunity to be the host in G20, we also invited them. You also, there was some what you call program that was conducted. We also invited them online एक कराया हमने कि आपकी भी बात हम रखेंगे. We will raise your voice. So when we took over the presidency of G20, we also conducted that is voice of global south. ताकि उनको जो बातें कहनी है वो हम कहें उनकी तरफ से. Whatever they want to say, we will speak on their behalf because we are the emerging power. So this is an easy thing, that is G20. Honestly speaking, इस पे भी there are a lot of things, but I will just stick to it. You just go through basic G20 because G20 question is expected. It was conducted in India. So 52 we will settle for C. Then we have 53. This was actually 12-13 January 2023 को ये summit हुई थी, Voice of Global South summit. Okay, although UPSC doesn't add dates and all. So 52C. हाँ, G20 you should know how G20 1999 after global recession in 2000, US recession in 2008, it became heads of the government. G20, India has now all the countries which are members, and how the new African Union, what are the steps taken by India, then what you call all such things related to G20, they can be. So we have next is 53, okay. 53 is what you call, now in midst of Israel's ongoing military attack on the Gaza Strip, United Nations Secretary General has invoked Article 99 of UN Charter. Article 99 of UN Charter gives a special power to Secretary General. It can draw the attention of Security Council on a particular matter. बहुत कम ऐसा हुआ है. Very rarely this article has been invoked. Secretary General using his own power can draw the attention of Security Council on a particular matter. So this was in the case. The adoption of the resolution requires approval from at least 9 member states with no vetoes from permanent. The resolution will only be accepted if it is approved by 9 member states and no veto should be there. This is an absolutely correct statement. Article 99 does not lead to immediate direct action because there is no immediate direct action. Since United Nations, UN Charter, United Nations Declaration on Human Rights, 10th December 1948, this question also has been asked in prelims. Basic understanding of UN Charter or UPSC ki purani aadat. Old habit of UPSC that dies hard and it will not die. They will ask an interdisciplinary question. When that crisis happened in Afghanistan, UPSC is a very intelligent body. Everyone on earth who is having little bit of intelligence knew that they are going to ask a question on map. उनकी आदत है वो interdisciplinary question पूछते हैं. When there was a humanitarian and refugee crisis in Afghanistan, it's not me. Almost everyone said in the class that they are going to ask a question on map. Because if there is a refugee crisis in Afghanistan and you are posted over there, so people will not go to troposphere. They will go to the countries that are sharing contiguous borders with Afghanistan. So UPSC is not concerned which day they came. 15th August was the date. What happened? They know. UPSC is concerned which all countries share border with Afghanistan. This was one of the most expected question that was asked next year, which was actually an out question. Any sensible person would have guessed with that experience कि ये तो पूछेगा ही पूछेगा. So UPSC has that habit of asking a interdisciplinary question. If there is an issue related to Afghanistan, they will not ask a political question. They will ask a geography question, and they ask the question which all countries share border with Afghanistan. So if this year they ask the question, if they ask a question, I'll be surprised because everyone knows that they are going to ask a question, geographical question related to West Asia and Ukraine. Map से related कोई question पूछेंगे, what is related to what is the, because they ask interdisciplinary question. If Sabrimala issue happened, so they ask the question from Kottam to Kohima. If you travel, how many states you will cross? So in which district, Pathanamthitta district, it is there near Periyar Tiger Reserve. So all these questions they ask, interdisciplinary questions. Okay. Particularly vulnerable tribal groups कौन है, Sabrimala temple complex, what is the tiger reserve over there, geographical. So interdisciplinary question. इससे भी they can ask. Now both the statements are correct. Under Article 99, the provision is Secretary General can invoke, but it requires the support of 9 members at least, and all 5 may nobody should veto. So this statement is also correct. This is also correct. I will settle for 53C. Okay. Then we have 54. Whatever things have happened in global context, you will also go through the current affairs related to geography, map and all those things. Okay. And one more thing. Whichever thing has happened, big level, not small events. Whatever big things have happened, you will also go through the provision. What is the kind of setup over there? What is that? जैसे France elections were held, immediately UPSC asked the question in mains, compare the presidential election in France and India. So if this year anything happened in 5 veto nations or Germany, some political understanding, there is a topic in mains comparing constitutions of the world. Okay. So if there is a judgment by US Supreme Court on not providing reservation to those disadvantaged groups in US universities, they ask the question in mains, what is the principle of equality in American Constitution vis-a-vis Indian Constitution? Before this judgment only they have asked. So anything that is of uttermost significance that is asked in, that is in news from other countries also, you will try to keep a note on that. Okay. So let's see this. You know, United Nations Convention on Law of Seas, 1982. You know, up to 200 nautical miles, you have exclusive economic zone. You know, within 12 nautical miles, you have exclusive right. आपको मालूम है किसी भी कंट्री का up to 200 nautical miles, they have exclusive economic zone. What is exclusive economic zone? Whatever is found over there, gold, diamond, crude oil, getting my point, whatever, sikka, just kidding. So whatever is found, they will keep there. So that is exclusive economic zone. Beyond 200 nautical miles, if you want to get something, then it will be International Seabed Authority that will give permission for polymetallic nodules and all. But there is other laws also. United Nations Convention on Law of Seas, there is 1982. There is a case I remember, North Continental Shelf case. International law में हमने college में पढ़ा था. So 2 countries were there. Within them, there was less than 200 nautical mile difference. So both of them were claiming pura complete exclusive economic zone. So in that North Continental Shelf case, the court decided कि नहीं, we will give half to this and half to this. So what you need to know, one, किसी भी country के coastal boundaries से 200 nautical mile you will be having exclusive economic zone. Whatever is found belongs to you. Beyond 200 nautical mile, if you want polymetallic nodule, that is in news because it is a bunch of metals, then that permission will be given by International Seabed Authority. Within 12 nautical mile, complete sovereign territory. Kuch bhi hoga, anybody will pass, they will take your permission. So let's read now, you know the information. A coastal state has a sovereign right over exploration and exploitation of natural resources, whether living or non-living. Exclusive economic zone. So this is the correct statement. A coastal state has sovereign right for production of energy from water currents, and this is also, a coastal state has no right to establish artificial island. Bilkul they have a right to establish artificial island. This is a wrong statement. A coastal state has a right to carry out marine scientific research. This is a correct statement. 1, 2 and 4 is correct. Then we have article 54C for Calcutta. That is only 3. Next question is 61. क्यों? क्योंकि आर्टिफिशियल आइलैंड आप बना सकते हैं. आर्टिफिशियल आइलैंड आप बना सकते हैं. व्हाट हैपेंड इन चाइना? पार्सल एंड स्पार्टले आइलैंड्स, परमानेंट कोर्ट ऑफ आर्बिट्रेशन रूल्ड इन फेवर ऑफ फिलीपींस. चाइना सेड 1, दिस इज नॉट अ सी वाटर डिस्प्यूट, इट इज अ टेरिटोरियल डिस्प्यूट. सेकंड, PCA, Permanent Court of Arbitration, can only interfere if both countries agree to their jurisdiction. China doesn't agree to their jurisdiction. So United Nations Convention on Law of Seas, they don't, they technically ruled in favor of Philippines, which was disregarded by China. That's a different thing. इसी वजह से when we study law in jurisprudence, कहा जाता है international law is no law. Many scholars say कि international law is no law because it is only imposed on the weak, not on the strong. So that is why international law को लेके China is like disregarding. Anyways, that's a different story. 200 nautical miles exclusive economic zone. They also have the right to build artificial islands. So this is something which is right. This is excluded. I'll settle for 1, 2 and 4. That is only 3. 54 ka C, 61 we have. 61. Let's see. Okay. Okay. Which of the following subject is not a part of concurrent list? बोलिए सब. Question है sir. This is an easy question. 1 or 2 easy questions are given so that you are also. But इसमें भी गलती करेगा. Many will mimic. Which of the following subject is not a part of concurrent list? Actually, the questions which have been first up there, honestly speaking, questions have been very good. I'm very satisfied because almost all the questions which I discussed is perfectly in line with UPSC. But अब ठीक है, अच्छे, बहुत very good questions. This question, because you need to have a healthy mix of fact also as well as concept also. This question में, I'm not concerned what you know, what you don't know. If you don't know, then it's fine. I can give you many examples where UPSC is not testing whether you know or not. UPSC is testing whether you don't know this also. Getting my point? बहुत से ऐसे examples हैं जहां ये test कर रहे होते हैं. For example, which of the following is not a member of one organization? So what they wanted to ask, that it is not possible for you to remember all the members of that organization, but they wanted to check whether you know that Iran is not a member of that organization. So कई बार वो ये नहीं check कर रहे होते हैं कि आपको आता है. What you know, they want to whether you can eliminate that or not. Get it? So you have to be very intelligent. Here, पूरे COVID में there was a discussion that public health is a matter that falls within the state domain. Public health is a matter that falls within the state domain. Marriage and divorce, concurrent list, you have all these things compressed, but you have public health is a matter in state. So, which of the following subject is not a part of concurrent list without any, land, public order, agriculture, policing, all these fall in the state. War and peace, extradition, United Nations Organization, defense of India, deployment of the forces of union, railways, insurance, communication, all these matters falls in central list. Environment नाम की कोई list नहीं है. Wildlife, forest, CRPC, CPC, getting my point? You have marriage, weights and measures, all these matters, education, all these matters falls within the concurrent list. So, which of the following is not a question? This is a very good question actually. Because इसलिए पूछा है ये question, ये नहीं जानने के लिए, they have not asked this question whether you know industrial and labor dispute bank. They actually are asking whether you know marriage and divorce due to uniform. Say this. Very good question. Due to uniform civil code and public health and sanitation is in news due to COVID. In fact, there is a demand to shift this from state list to concurrent list so that central government is effectively implementing the provision. And this is also related to the NEET bill that has been passed, NEET Act 2019, and Legislative Assembly of Tamil Nadu trying to overcome, which is pending with President. In general, matters related to public health, the Constitution of India places under the state list, so we'll settle for 61D for Delhi, which is not in a concurrent list. 62 and 63, okay. 62, which of the following statement best describes the concept of negative liberty? So, the freedom to pursue one's own goal and interest. This question was asked by UPSC, this is positive liberty. And what UPSC asked, liberty is absence of restriction. No, liberty is absence of unnecessary restriction. Samajhiye. No society in the world can exist without any restriction. If there is no restriction, then what will happen? You will go out, somebody will snatch your phone. You will move ahead, you will snatch someone else's phone. Somebody is wearing a what you call a blue shirt, you will say, no, I don't like blue, go and change. So, liberty is not absence of restriction, absence of no society can exist without restriction, otherwise somebody will kill someone else, somebody will. So there are restrictions, only necessary restrictions, unnecessary restrictions should not be. So UPSC asked the question, liberty is absence of restraint, which was a wrong statement, just because one word was missing from there, absence of unnecessary restraint. But there can be, if there is no necessary restraint, then anybody will murder anyone. If there is no necessary restraint, then anybody will go for theft, IPC 379, and go for criminal conspiracy, IPC 120B, go for defamation, IPC 499. Getting my point? So, samaj mein restriction hona, in the society you need to have restriction, only necessary restriction, not so liberty doesn't mean absence of restriction. Liberty means absence of unnecessary restriction and presence of necessary restrictions. Okay. This is negative liberty. Positive liberty is to provide you the opportunity to develop fully. So give you such capabilities, such skill set so that you expand yourself. This question was asked by UPSC. Expansion of one's own choice or one's own ability. Matlab overall growth of an individual. So which of the following best describes negative liberty? This is more close to positive liberty. Absence of external constraint. This is the correct thing. Let's see आगे क्या है. Exercising liberty to pursue negative goals. अच्छा, negative goals. The right to equal treatment under the law. This has nothing. So the answer would be 62B for Bombay. That is absence of external constraint or interface. Some UPSC also gives these kind of options. You have to be very vigilant. So we'll settle for 62B. If you want to read further, class 11th political theory, best book of NCERT, one of the best book that has to be read compulsorily. In last so many years, UPSC has consistently asked one question from that book. Okay, that is class 11th political theory. We have 62. Now we have 63. 6. Consider the following statement regarding parliamentary standing committees. This is one of the easiest question till now. Parliamentary standing committees are permanent committees. Yes, they are permanent committees. There are 24 such committees. 16 come under Lok Sabha, 8 come under Raj Sabha. 31 members are there. 21 from Lok Sabha, 10 from Raj Sabha. They are nominated by the speaker for 1 year. It is started from 1993. Initially there were 17 committees. In 2004 they increased from 17 committees to 24 committees. Samajh rahe na? Initially they were from 1993 to 2004. How many committees? 17. From 2004 how many committees? 17 to 24. Initially there were 45 members, 30 from Lok Sabha, 15 from Raj Sabha. Now they have 31 members, 21 from Lok Sabha, 10 from Raj Sabha. These बाकी committees में election होता है. Estimates committee, public account committee, committee on public undertaking, STVPR. In this committee there is no election. It is nominated by the speaker. and the chairman respectively. 16 committees are serviced by Lok Sabha, 8 committees are serviced by Raj Sabha. It is a 3-hour topic, but DRSC is important. Mains mein they have asked the question. Anyways, Parliamentary Standing Committee or Permanent Committee is correct. Recommendations made by Parliamentary Standing Committee are binding on government. No recommendation of these committees are binding on. There is no body where Finance Commission, Election Commission of India, National Commission for Scheduled Caste, Scheduled Tribe, Backward Classes, किसी के भी recommendations government पे, National Human Rights Commission, कोई भी recommendation binding नहीं है. Getting it is not binding on the government. So recommendation, members of parliamentary standing committees are elected. No, standing committee members are nominated by the speaker and chairman. अगर यही होता public account committee, committee on public undertaking, estimates committee, then we would have said they are elected. But in DRSC, why? Because सबको मिलेगा, कोई नहीं YouTube comment में दे write ना, सबको मौका मिलेगा. Getting my point? So here there are 24 committees. In every committee there are 31 members. So you don't have any such rush. Everybody will be so, and ministers cannot become members. So already 60-70 people who are ministers are reduced. So everybody will get an opportunity to become a member of a parliamentary committee. So there is no rush. So here members are not elected, but they are getting my point, but nominated. So this statement is wrong. This statement is wrong. We'll settle for 63, only one A. Then we have 64. Just few questions are left. Now this is an easy factual question. Grassroots Innovation Forum often appears in notes. It is related to ASEAN. Getting my point? That is a group of countries known as ASEAN. Actually, this initiative, India is also a part. They say to STI, okay, Science, Technology and Innovation. Iska jo code hai. And then they are promoting collaboration and all those facts. Pure factual aspect, just go and read about them. Okay, so we'll settle for 64C. Then we have 65. Now, this is a wonderful question and pure UPSC type question. UPSC enjoys assassinating at those places where you are weak. If they know that they will ask constitution, they will ask fundamental rights, DPSP, parliament, judicial review, National Commission for Scheduled Castes, Special Officer for Linguistic Minorities, Union and Territory, Citizenship, Preamble, everyone will answer. If they will ask periodic journal, if they will ask Official Secrets Act, Indian Prisons Act, land reforms, then students in what you call right of fair resettlement, rehabilitation, or the provisions related to Flag Code of India, then students are not. So this is actually a topic that we were dealt in current affairs, though there are very few questions we have. Okay, let's see this. Recently, Parliament passed Press and what you call Registration of Periodicals Act. Okay. So in this, newspaper is covered, comment on public news is covered. So that is which of the following are covered? Books are not covered. Books are not covered in this. Books alag. Scientific journals are not covered in this. So 1 and 4 are covered. So we'll settle for B. 65 B for Bombay. This is purely a factual question. Okay. Just go and समझने से ज़्यादा इसमें fact है और fact के question रहते हैं. More it is about fact. I cannot be of any help because you have to memorize them and they will be trapping you in questions where you have facts. If you go through Vision ABHYAAS current affairs, I myself have discussed this in current affairs, I remember. So you will find that. Okay, so please go through the current affairs diligently. 65B, then we have 66. Let's see. 65B is there. Okay. With reference to parliamentary tools, consider the following statements about point of order. Many years back, I was watching the proceedings of parliament. Sushma Swaraj ma'am was there in opposition. So I still remember that there was a point of order raised. In general, when you watch the proceedings of parliament, in general, opposition parties raise. There is no such rule, but in general, who raises this? Opposition party. When you see that the house is not going, quorum nahi hai, how somebody is doing something which is against, for example, you are talking to someone and you are ऐसे और भाई टिफिन क्या लाए, getting my point. So if you are showing your back to the chair, getting it. For example, there is no quorum in the house. For example, there is there are certain rules. एक list of words होते हैं. These words you cannot use in the parliament. They are called unparliamentary. So if you used any of the words, so although in that speaker chair will also take an action, here some proceeding is going on where it is explicitly mentioned that you will not mention something related to an ongoing case. ये parliamentary convention है. Sub judice matter discuss नहीं करते हैं. Any matter which is pending in the court is not discussed in the parliament because उसी तरह article 120 122 of the Constitution and 121 of the Constitution. The conduct of judges of High Court and Supreme Court cannot be discussed in Parliament except when their removal motion is going on. Article 121. And the proceedings of Parliament cannot be called into question in any court on grounds of irregularity of procedure. Article 122. उसी तरह point of order तब raise किया जाता है. It is raised when you see that the House is not going as per the rule. House is not going as per the rule. Discussion नहीं होगा उस पे. The person, if he stood up and he says कि there is point of order, then there will be no discussion. अच्छा इस पे आप अपना ज्ञान रखिए. No, he will not be allowed to speak further. You have raised that point. Chair will take note. If the chair feels that yes, he is correct, then necessary corrections will be done. But there will be no discussion. Okay. So it can be raised by any member. Usually raised by the opposition, but I said this, कि there is no such rule, it can be raised by any, but practically I have seen this being raised by the opposition, but you know, I said in the beginning only, कि ऐसा कोई rule नहीं है. Okay. Just because tomorrow UPSC can ask a question, it is usually raised by an opposition member, then it would be a correct thing, but there is no such rule, anybody can. No debate is allowed on a point of order, absolutely correct, so we'll settle for 66 ka C. Then we have 67. Let's see. 67. Okay. Consider the following. It operates within the framework of United Nations. It was formed in response to Second World War. Second World War, ILO nahi. Response to Second World War, India is member related to Geneva. So correct answer would be International Organization for Migration. India also became a member. Correct answer would be International Organization for Migration. Okay. So you know that International Court of Justice is more of an old, getting my point, it has an origin. Here this organization was with respect to resettlement and all such things. So we will settle. This is purely a factual question. We will settle for C. गौर से सुनिए. They are going to ask a question on international law or international organization. International law you don't need to remember, but few, because इतना सारा कुछ हो रहा है, so many things are happening. United Nations Convention on Law of Seas, basic United Nations Declaration of Human Rights, United Nations Charter, in सब से एक question इस बार prelims में they are going to ask. So I think you should be conscious, not too deep, but at least things that are happening, basic aspect of UN Charter, you should have an idea. United Nations Declaration of Human Rights, okay. Those things UPSC, non-aggression, all these things UPSC may ask. Okay, so I'll settle for C. Last question that I am assigned to discuss, that is question number 68. Let's see. Now this is an easy question. Legal aid आया, बस Article 39A of the Constitution. तीन चीजें कहता है. One, the operation of legal system in India should promote justice. जो पूरा legal system है, it should promote justice. The state shall provide free legal aid. And third, no one shall be denied justice by economic or any other disability. That is there. So तीन चीजें हैं आर्टिकल 39A में. पहला, ऑपरेशन ऑफ इकोनॉमिक सिस्टम शुड प्रमोट जस्टिस, इंसाफ, देयर मस्ट बी जस्टिस प्रमोटेड बाय आर्टिकल 39A. दूसरा, नो वन शैल बी डिनाइड जस्टिस बाय वे ऑफ इकोनॉमिक और एनी अदर डिसेबिलिटी. थर्ड, द स्टेट शैल प्रोवाइड फ्री लीगल एड. To implement Article 39A, Parliament has passed the Legal Services Authorities Act 1987. Okay, so that law is there. उसमें 6 bodies है, आ सकता है. 6 bodies, please remember. The National Legal Service Authority, the State Legal Service Authority, District Legal Service Authority. तीसरा इधर Supreme Court Legal Service Committee, High Court Legal Service Committee and Taluk Legal Service Committee. This UPSC has not asked till date. UPSC 2020-21 में they asked the question 20 or 21 में, who among the following is entitled for free legal aid? OBC, SC, ST, not OBC. So that was a wrong statement. You eliminate, you get an answer. That they have already asked. Now they are going to ask 6 bodies. The Legal Service Authority, National Legal Service Authority, State Legal Service Authority and District Legal Service Authority. Supreme Court Legal Service Committee, High Court Legal Service Committee and Taluk Legal Service Committee. I remember, but I will not, ample of time it will take. Go, who establishes, who is the patron and chief? What is the function? Function of 2 organizations is not given. Supreme Court Legal Service Committee and High Court Legal Service Committee, function is not given in the Act. That National Legal Service Authority and State Legal Service Authority will decide. Who is the chairman? What is the there? Who, all such things you remember. 6 bodies are there. Let's see this question number. This is the last question. Okay. So, with reference to judicial initiatives in India, consider the following statement about Legal Aid Defense Council system. It is a project executed by National Legal Service Authority. It offers free legal aid and assistance to individuals in civil and criminal cases. No, in civil cases not. So it is, so this statement is eliminated in not in civil cases. Getting my point? Kyun? Why? Because then everyone will think if you are getting free lawyer, let's file a case against him. Getting my point ना? So usually what are the eligibilities? सबसे पहले तो act में जो eligibility दी है S1 SC, second ST, third women, fourth a person who is under custody, fifth a person who is industrial workman, sixth a person who is differently abled. Then you have what you call the provisions related certain what you call other deprived sections of the society. That is said. Mainly it is what you call victims of undeserved want. Article 41 of the Constitution, they have used the term undeserved want. Okay, victim जैसे anthropogenic disaster or mainly natural disaster, flood, all such things. Okay, these are eligible. So criminal cases, civil cases, nahi, we will eliminate this. This is a correct statement. Lawyers involved in this legal aid defense counsel system are prohibited from taking on private cases so that they concentrate main on this. This is a correct statement. Two statements are correct. 1 and 3 will settle for option 68 ka B. This is there. What you need to remember, additional reading, 6 bodies which I have mentioned, they are going to ask today or tomorrow. That they have not asked, they have already asked other aspects of. Then you will read Article 39A of the Constitution. And most importantly, difference between the Legal Service Authorities Act and Gram Nyaya Act 2008. And there is a case, National Federation of Societies for Fast Justice. In general, what is the difference between Gram Nyaya Act and the Legal Services Authorities Act? UPSC asked this question because as a responsible citizen, you must know the issues arising out of pending cases in India. So this is alternate dispute resolution. Alternate dispute, alternate way to solve the dispute other than conventional mechanism. And of course, Gram Nyaya's Act also remains important. Okay, the Legal Services Authorities Act also remains important. So we are wrapping up the conversation. There were 24 questions that we have discussed. We breached mandate by 40 minutes. Okay. So we will, other faculties would be coming and they will be, I was discussing polity, current affairs, as well as the static, IR current affairs as well as static, social, just there were 2 questions only. So then other topics will be dealt by the faculty. Okay. Thank you.